Hello, everyone. Very warm welcome to our latest Fenwick Elliott webinar. It is great to be back here with you again today. My name is Stacey Sinclair, and we've taken a very short break, but today we are back with our latest adjudication update. And it's fantastic to see so many of you with us here today. I can see we still have a number of people joining, so welcome. Right, for those of you who today is your first time joining us, this is actually our 7th adjudication update since we started this webinar series back in May 2020, which was at the outset of the first UK lockdown. And if you're interested to look at all the case law that we've reviewed since then, if I can point you in the direction of our website, and you'll find all of the slides and on-demand recordings of the whole series of those adjudication updates. Now, our last one was back in February of 2022. So today's panel is going to bring us up to date since then, focusing on the key cases and what we need to know. And with that, if I can introduce to you today's panel, we have two of our senior associates from Fenwick Elliott, Adele Parsons and James Mullen, both of which specialize in construction and energy law, all forms of dispute resolution, both domestically and internationally, of course, including adjudication. And they are joined by Pump Court barrister, Daniel Turcher. Hi, Dan. Who will be known to many of you who have joined us in our previous adjudication updates. And we're delighted to have our resident expert back here again with us today. Dan, of course, is a specialist in construction and energy law and all forms of dispute resolution as well. So before I turn over to our panel, just a reminder, everyone is on mute. Please do ask questions as we go, and we will try and take a couple of those at the end. You'll find the question box toolbar in the usual way on the right-hand side of the screen. And again, rest assured the slides, which are very thorough, which is fantastic, and the on-demand recording will be available on our website in due course. So with that, we just have up here for you today's agenda, which is really a list of the cases that Adele, James, and Dan are going to take you through. And hopefully that will provide you with a list afterwards as to what we have covered. So I think, Adele, with that, I shall hand over to you.
Great, thanks, Stacey. Hi, everyone, and welcome to today's session. Now, I'm going to start by looking at a couple of cases on the tricky interplay between the insolvency and adjudication regimes, which, by all accounts, has been quite a hot topic since the Supreme Court's judgment in Bresco versus Lonsdale. So today I want to start by discussing this case of ML Hart versus Swiss Cottage, as it not only deals with insolvency in the context of adjudication, but serves as an important guidance on when an adjudicator must resign if a party refers a dispute to an adjudication that is the same or substantially the same as one which has previously been referred to another adjudicator. So sort of the key question that this case answers is, when is that second adjudicator expected to resign? Now, as a reminder, paragraph 9.2 of the Scheme for Construction Contracts requires that an adjudicator resign if a dispute referred to them is the same or substantially the same as the dispute that was previously referred to adjudication and a decision was taken. So what does that mean in practice? Well, essentially, what is the same or substantially the same is a question of fact. However, in the context of this case, the key point to consider is whether a decision was taken in that first adjudication. So moving on to the facts. In 2013, Swiss Cottage employed ML Hart under a JCT formal contract to demolish a pub and design and construct 14 residential apartments in London. Now, following the execution of that contract, Swiss Cottage actually entered into a guarantee bond with Aviva Insurance Limited. Now, that bond stated, amongst other things, that in the event of the contractor's breach of contract or insolvency, Aviva, as surety, would satisfy and discharge damages sustained by Swiss Cottage as established and ascertained pursuant to and in accordance with the provisions of or by reference to the contract, and taking into account all sums due or to become due to ML Hart. Oops. Sorry. Oh, there we go. Now, in 2015, ML Hart entered into creditors' voluntary liquidation, which is considered an insolvency termination event that triggers various obligations under the contract, including an obligation on Swiss Cottage to submit a statement of final account, as it was required to do under clause 8.7.4 of the contract, which I've got there on the slide, and which provides that if the contractor's employment is terminated due to an insolvency event, then following the completion of the works and the making good of defects in them, Swiss Cottage will, within 3 months, prepare an account setting out the following. And then you've got the amount of expenses properly incurred by Swiss Cottage, any direct loss and/or expense for which the contractor is liable, whether arising as a result of the termination or otherwise, the amount of payments made to ML Hart, and the total amount which would have been payable for the works in accordance with this contract. Now, as a result of that initial assessment, Swiss Cottage claimed some $435,000 from ML Hart. ML Hart, in response and by way of attempted offset, claimed that $200,000 was in fact due to it. Now, in light of the figures claimed by Swiss Cottage and ML Hart, and in light of the guarantee bond I was discussing a few minutes ago, Aviva and Swiss Cottage entered into an acceptance agreement in 2017, for which ML Hart was not a party, and under which Aviva agreed to pay the difference between Swiss Cottage and ML Hart's assessments. Now, as a result of that acceptance agreement, ML Hart initiated adjudication proceedings in which 2 issues were put before the adjudicator. The first was whether the acceptance agreement between Aviva and Swiss Cottage, setting out sums payable under a guarantee bond, prevented assessment of the termination account under this clause 8.7 of the building contract. And secondly, if not, i.e., if an assessment was to be carried out, what decision should be reached in respect of that assessment. Now, on issue 1, the adjudicator determined that the terms agreed between Aviva and Swiss Cottage in the acceptance agreement amounted to a contractually compliant assessment of ML Hart's entitlement under clause 8.7, even though ML Hart was not a party to that agreement. And on the second issue, given the acceptance agreement was considered a valid assessment under the contract, the adjudicator found that he didn't need to make a decision in respect of the second issue as referred to him. As a result of the adjudicator's decision, ML Hart made an application to the court under Part 8 seeking a declaration that the decision of the adjudicator was wrong and therefore not binding upon the parties. Now, the court agreed with ML Hart, finding that the acceptance agreement between Swiss Cottage and Aviva between Swiss Cottage and Aviva could not be classed as an assessment of the final account as required under the termination provisions, nor did it contain any such assessment. And you can see there that in his judgment, Mr. Roger Tahar QC stated that clause 8.7.4 contemplates a statement having primary efficacy as between the parties to a construction contract. An agreement between the employer and the surety settling liability under the bond is not an agreement on its face, having efficacy between the parties to the construction contract. Now, as a result of that decision, the court then had to determine whether ML Hart was entitled to launch a fresh adjudication on that second issue. The court held that a second adjudicator was indeed free to decide the second issue, i.e. the value of the termination assessment, on the basis that the first adjudicator did not actually make a decision on issue 2. Now, in making this decision, the court considered the authority of Hitachi versus John Sith, which addressed the claim that a dispute as referred to an adjudication in the 8th adjudication between the parties had already been determined in a second adjudication between them. And you can see there from the part of the judgment I've highlighted on the slide that the key comparison to be made is between what was referred in the 8th adjudication and what was decided in the second. So ultimately, this judgment of ML Hart highlights 2 key points. The first is that a third-party agreement to which the contractor is not a party is unlikely to be capable of replacing the assessment upon termination mechanism in the building contract, unless your contract states expressly otherwise. And secondly, when determining whether a given issue is the same or substantially the same as a dispute which has already been referred to adjudication, one should not only look at the first dispute referred to the adjudicator in isolation, but also consider what was actually decided. So, sticking with the insolvency theme, the next case I wanted to discuss is the recent case of FTH Limited versus Faris, as this looks at whether the courts will summarily enforce adjudication decisions where the claimant is subject to a company voluntary arrangement or CVA. I would say from the outset that it's well established that in adjudication enforcement proceedings, just because a company is in a CVA, it doesn't mean that summary judgment will be refused or a stay of execution will be granted. Indeed, this was outlined by Lord Justice Coulson in the Court of Appeal's decision in Bresco versus Lonsdale, where he drew a distinction between a party in a CVA from a party in insolvent liquidation. And as you can see from the slide, here he said that the general position relating to the CVA may, depending on the facts, be very different to the situation where the claimant company is in insolvent liquidation. The CVA is or can be conceptually different. It is designed to try and allow the company to trade its way out of trouble. In those circumstances, the quick and cost-neutral mechanism of adjudication may be an extremely useful tool to permit the CVA to work. In those circumstances, courts should be wary of reaching any conclusions which prevent the company from endeavouring to use adjudication to trade out of its difficulties. On one view, that is what adjudication is there for, to provide a quick and cheap method of improving cash flow. So the question of whether summary enforcement will be granted is based on whether there's a real risk that a summary enforcement may deprive a defendant of security for its cross-claim, which is very much dependent on the facts. And now looking at those facts in FTH v. Barris, now in this case, FTH sought summary enforcement of 2 adjudication decisions it had obtained against Barris. The first upheld the validity of a payless notice, and the second concluded that Barris had terminated the contract by repudiatory breach. Barris accepted that they were valid awards, but resisted enforcement and or sought a stay on the basis that FTH's financial position and that it had its own cross claims of 1.7 million. Now in court, FTH submitted that they were now carrying out work and receiving revenue. However, as Barris pointed out, FTH failed to provide substantial evidence that they were trading profitably. Barris also highlighted that FTH's CVA was not on its face designed to allow FTH to trade its way out of trouble. For example, even if the CVA fulfilled all of its financial expectations, there would only be a recovery of 56 pence to the pound. And on top of that, the CVA was for 12 months only, it having not been validly extended. In addition, Barris submitted that the CVA supervisors had also not considered the Barris cross-claim put in at this 1.7 million, and that if this succeeded in whole or in significant part, the CVA would fail and FTH would go into liquidation with very little, if any, recovery for creditors. Ultimately, therefore, Barris submitted that there was a real risk that summary enforcement would deprive them of security for their counterclaim. Now, the judge sided with Barris in this one and refused to enforce the adjudicator's decision. The starting point for that conclusion was the case of Boyks versus Dell Jensen that I referred to on the slide, which held that when a company in insolvent liquidation has obtained an adjudication in its favour, the decision will not generally be enforced due to the risk that the other side would be exposed if it were not able to recover costs and or cross claims if they were successfully made out. However, that case did acknowledge that a CVA differs in form from a party in insolvent liquidation, as we've discussed just now. So the second consideration for the court was the case of Bresco, as this explained that the purpose of a CVA is to enable a company to trade its way out of financial trouble. And in such circumstances, adjudication could indeed be a quick and cheap method of improving cash flow and permitting the CVA to work. However, Bresco also highlighted that this was again very much fact dependent, and that there was the added difficulty that the court provided no definitive guidance on the approach to be taken in cases involving CVAs and the enforcement of those adjudication decisions. So considering these authorities and the facts, the court decided that there remained a real risk that defendant would be deprived of adequate or any security in respect of its cross-claim if it enforced the decisions. Namely, that as Varys had pointed out, and unlike in Bresco, the particular CVA in this case was not designated to allow the claimant to trade its way out of trouble. The court was also not persuaded that the claimant had recently been trading profitably, that in fact FDH's financial position looked rather bleak, and that FDH had been somewhat economical with information relating to its financial position. So ultimately, the court found that the claimant would be unable to repay the judgment sum if the matter went to trial, and the adjudicator's decision was overturned. Now, one final point I just wanted to raise with you on this particular case is that Varys had also applied for a stay under the principles set out in Wimbledon versus Vago. Now, as a reminder, these are set out in the slide shown here, and for timing reasons, I won't go into them in any detail. And as Stacey said, these will be made available in any event after the webinar. But in considering those principles, the court found that it did not consider it necessary to grant a stay because he had refused summary judgment. The judge did, however, note that the courts expect parties in the position of FTH who wish to avoid a stay to provide detailed and reliable information in respect of its financial position, a test which, as I've just discussed, FTH simply had not satisfied. So given this, then that FTH's financial position was not due wholly or in significant part to Varys's failure to pay the adjudication award, the judge opined that he would have granted a stay if required. So essentially, this case and the decision once again raises questions around the utility argument used in Bresco, namely, if a court is reluctant to enforce an adjudication decision when a party is experiencing an insolvency event, is there any point in that party obtaining the adjudication decision in the first place? Given the authority of Bresco and the weight that was afforded to the facts in this particular case, there is an argument that in some cases it would still be worthwhile pursuing adjudication. But in my view, such cases are very limited and very much dependent on there being adequate security ring-fenced for any potential enforcement. So thank you, that's my cases for today. So with that, I'm now going to hand you over to James.
Great, thank you, Adele. Right, so the topic, the first topic that I would like to review with you today, there's two. This first one is, to what extent does an adjudicated decision on an interim application bind parties in relation to the final account? Now, this issue was considered in the case of Essential Living and Elements Europe. Just briefly by way of background, Essential engaged Elements for the design, supply, manufacture and installation of modular units on a mixed-use development project in London. The contract incorporated the JCT Trade Management, the JCT Management Trade Contract. In July 2019, there was an adjudicated decision which valued Elements as works up to March 2019, and in the decision, the adjudicator valued sums for variations, rectifications of defects, and LADs for delay. In May 2019, PC was certified. Not long after, Elements submitted its documents for the purpose of calculating its final account. There then appears to have been a period of delay, and then in 2021, disputes arose over the binding nature of the 2019 adjudication decision on the final account. Those disputes could not be resolved, and so in October 21, Essential issued Part 8 proceedings seeking various declarations. Oops. The declarations that Essential sought are on the screen. Essentially, in relation to LADs, Essential sought a declaration that the LADs and the finance charges that it had been awarded by the adjudicator, that it was entitled to retain those sums unless and until the adjudicator's decision was overturned, modified or altered by the court. In relation to EOT, it sought a declaration that Elements was not entitled to any further EOT beyond that which had already been assessed and awarded by the adjudicator in the adjudicator's decision, again, unless until overturned, modified or altered by the court. And it sought a declaration that there was no provision in the trade contract which allowed the construction manager to review, reopen, modify or alter the EOT, LADs, finance costs or valuations assessed and decided in the adjudication decision. And it also sought certain declarations in relation to Elements' ability to claim loss and expense. The issue before the court really was what is the binding effect of the adjudication decision and its impact on subsequent contractual processes, in this case, the final account process. In particular, what was the impact of the adjudication decision on claims for EOT, LADs, delay damages, and what was the impact of the adjudication decision on the evaluation of the final trade contract sum, including variations and loss and expense. Mrs. Justice O'Farrell gave the judgment, and her findings were summarised neatly at paragraph 84 of the judgment, which are on the slide in front of you. The first 2 points there are well known, well established. The third point, Mrs. Justice O'Farrell found that the adjudication decision was not binding for the purpose of the construction manager's final determination of the completion period, which in turn is intrinsically linked to the LADs and the finance charges. This is perhaps not very unsurprising, given that the adjudication decision concerns an interim application or an interim valuation. The adjudication decision was not binding on the parties for the purpose of determining the final trade contract sum. However, the adjudication decision was binding on variations considered and assessed by the adjudicator, unless and until the decision was overturned, modified or altered by the court, or unless either party identifies a fresh basis of the claim that permits such variation claim to be opened up or reviewed under the terms of the contract. And in relation to any other discrete issue that was referred to or determined by the adjudicator, it was a matter of fact or degree as to whether the adjudication decision was binding in relation to those discrete issues. The second topic I'd like to discuss is the recent cases concerning payment disputes, and everyone's favourite topic regarding smash and grab adjudications and true value adjudications. Now, I think everyone is by now well familiar with the rule in S&T and Grove, where the Court of Appeal held that an employer has the right to bring a true value adjudication, but that right is subject to the employer first complying with its obligation to pay a notified sum. And the first case, which came out in April this year, which I'd like to just discuss, is Bexheat and Essex Services Group. And the reason for that is that the judgment contains, towards the end, quite a helpful reminder and summary of the relevant legal principles in relation to the relationship between smash and grab adjudications and true value adjudications. Just quickly by way of background, ESG were an MEP subcontractor, and they subcontracted the plumbing aspects of their works to Bexheat. Now, in this case, it was a bit different to the usual situation, where usually you have a smash and grab adjudication comes first and the true value adjudication comes second, where the employer seeks to recover the money it lost under the smash and grab. But in this case, the true value adjudication came first. So very briefly, in July 2021, Bexheat submitted its interim application for payment 22, which valued the works up to the end of July 21. ESG issued a pay less notice. Bexheat commenced a true value adjudication. And in October 21, the first adjudication decision was issued, and it decided that the true value of application 22 was 1.3 million, and that a payment of 141,000 was due to Bexheat. ESG complied with that decision and made payment. Next came the next application, which was application 23, and that was submitted in August 21, one day prior to Bexheat commencing the first adjudication. That valued the works up to the end of August 2021 and sought a payment of £706,000. Now, annoyingly for ESG, they served their pay less notice 1 day late. On that basis, Bexley commenced a smash and grab adjudication. That was commenced 6 days after the decision in the true value adjudication. Unsurprisingly, the adjudicator in the second adjudication decided that ESG had failed to issue a valid pay less notice, and so the sum claimed by Bexley, i.e. the £706,000, became the notified sum and was due to be paid. ESG failed to pay, and so Bexley commenced enforcement proceedings. The starting point for Mrs. Justice O'Farrell was to consider the impact of the first adjudication, if any, on the second adjudication, and in relation to that, she had to consider whether the first adjudication was the same or substantially the same dispute as in the second adjudication. Mrs. Justice O'Farrell decided that it was not, and this was because the first adjudication concerned the true value of application 22, not the true value of application 23. Also, the second adjudication concerned whether a valid pay less notice had been served in response to application 23. As part of its arguments that it raised to resist enforcement, ESG argued that it was entitled to rely upon and enforce the first adjudication true value decision against application 23, even though it had failed to serve a valid payment or pay less notice in respect of that application. Again, the judge dismissed this argument, pointing out that the applications covered different time periods, noting that ESG did not raise a true value jurisdictional challenge in the second adjudication, and so it had failed to reserve its position, applying the principles of Bresco, again highlighting the importance of reserving your position when necessary and appropriate in adjudications. And also she found that if ESG had wanted to rely on the true value adjudicated in the first decision, it should have raised it in a pay less notice against application 23. But it had failed to do so, and so the sum claimed in application 23 became the notified sum. Lastly, there was a provision in the clause in the parties' contract which purported to allow an unqualified contractual right to set off against an adjudicator's decision. The judge decided that this provision offended the Construction Act and also the scheme, which provide that an adjudicator's decision is binding and requires the parties to comply with it. So for those reasons, Mrs. Justice O'Farrell decided that the second decision was valid and it was enforceable. As I mentioned at the start of this case, Mrs. Justice O'Farrell provided a helpful review of the relevant legal principles in relation to smash and grab adjudications and true value adjudications, and they were summarised at paragraph 76 of her judgment, which is on the slide. It's relevant to note the last two principles there, which are relevant for the next case, which I'll be coming on to shortly. They are that the entitlement to commence a true value adjudication under section 108 of the Act is subjugated to the immediate payment obligation in section 111, and unless and until an employer has complied with its immediate payment obligation under section 111, it is not entitled to commence or rely on a true value adjudication under section 108. So until fairly recently, the cases before the TCC have considered situations where there was an adjudicator smash and grab decision which had concluded that a notified sum was due and paid, and this meant that a party could not commence a true value adjudication until it had paid the notified sum. However, the question arises as to whether a party can commence a true value adjudication where the other party says that is entitled to be paid a notified sum, but it has not obtained a smash and grab decision to that effect. This issue has recently been considered in the case of AMC Construction and the Dahl Ammon Trust. The decision is dated June 2022, but the judgment has only recently been made available. Just briefly, by way of background, that was a charitable trust. It had engaged AMC to construct a mosque. The contract was a construction contract. It was based on the JCT form and therefore provided for interim payments. In 2021, that commenced a true value adjudication. The adjudicator's decision was issued in November 21, deciding that that had overpaid AMC. AMC did not like this, and so they issued Part 8 proceedings. AMC sought declarations that the adjudicator's decision was unenforceable on the basis that the adjudicator lacked jurisdiction following DAT's failure to validly serve the notice of adjudication. However, AMC also argued that the decision should be set aside on the basis that it had submitted 2 separate default notices and that had failed to serve a valid pay less notice in respect of either. Accordingly, there was a sum that had to be paid to AMC. Before that was entitled to commence the true value adjudication, applying the principles in S&T, and that's even though AMC did not have an adjudication smash and grab decision in its favour. Turning briefly to the first point regarding the validity of service of the notice of adjudication, it's obviously settled law that the adjudication notice of adjudication must be properly served on the responding party, and it must be properly served on the responding party before the referring party can apply to the adjudicator nominating body. If it's not validly served, then there's no jurisdiction and the adjudication is a nullity. Now, the issue in this case was that there was no dispute between the parties that a process server had pushed an envelope through the door of AMC's registered office, which was also the home of the 2 shareholders, Mr. and Mrs. Anwar. But the question was, did the envelope contain the notice of adjudication? AMC's case was that it didn't. The issue was raised during the adjudication, and the adjudicator decided that it did include the notice of adjudication and decided not to resign. However, in the Part 8 proceedings, there was witness evidence from Mrs. Anwar, that solicitor, and the process server. And having considered all the factual evidence, Mr. Tahar QC, who was sitting as the Deputy High Court Judge, said that he preferred the evidence of Mrs. Anwar. He concluded that the envelope did not contain the notice of adjudication, and so the notice of adjudication had not been validly served, and so the adjudicator lacked jurisdiction. So given his findings on this first issue, it wasn't strictly necessary for Mr. Tahar QC to consider the other arguments raised by AMC, but he did. In his judgment, he noted that unusually AMC had relied in the alternative upon 2 different default notices for 2 very different sums. Now, in relation to the first default notice, AMC said that this had been submitted in March, on the 11th of March 2020, for the sum of £809,000. However, at trial, AMC accepted that the document did not strictly comply with the requirements of the contract. So unsurprisingly, the judge decided that the first default notice was not valid. In relation to the second default notice, in July 2020, which, to remember that the true value adjudication was sometime after in 2021, AMC sent DAT's representative a letter which attached an updated valuation of the works up to March 2020, and it claimed a sum of £206,000. Now, the letter enclosed a schedule which was headed interim payment notice pursuant to under the relevant clause of the contract. DAT argued that the second default notice wasn't valid on the basis that it was issued 4 months after the relevant payment cycle. But also, AMC had never withdrawn the first default notice, and in fact, it had continued to rely upon it in the Part 8 proceedings. That argued that the relationship between the 2 documents was never explained. It wasn't clear, was the sum that AMC was saying that should pay £809,000, or was it £206,000? Unfortunately for that, the judge sided with AMC. He accepted that the statutory machinery as reflected in the contract only permitted 1 payment application and 1 payment notice per period. However, as he had decided that the first default notice was invalid, service of the second default notice was permissible. He also rejected DAT's argument that the second default notice was confusing, saying that it must have been clear that it was intended to be a formal notice under the relevant provision of the contract, and so it superseded any earlier valuation or application for payment. Therefore, he decided that the second default notice was valid, and as there had been no payment or pay less notice issued against it, the sum of £206,000 was due to that from AMC. Following on from that, AMC argued that that could not commence a true value adjudication until it had paid the amount due to it. And in his judgment, the judge went through the legal principles summarised by Mrs. Justice O'Farrell in Bexheat, and in submissions that argued that AMC had misread the authorities, and it sought to distinguish the principles in Bexheat as well as S&T and M. Davenport from the present case on the basis that AMC were not allowed to prevent DAT from commencing a true value adjudication unless it had first obtained a monetary adjudication award in its favour, i.e. unless it had first obtained a smash and grab adjudication in its favour. Mr. Tahar did not accept that submission, and he decided that that could not commence a true value adjudication until it had paid the amount he found to be due, even though AMC had not obtained a smash and grab decision in its favour. His reasoning is set out at paragraphs 103 to 106 of his judgment, which I won't read due to timing reasons, but it's on the slide if you'd like to read it. And you see there at paragraph 107 of his judgment, he refers to those two principles summarised by Mrs. Justice O'Farrell in the Bexheat decision. Therefore, he decided that that weren't entitled to commence a true value adjudication, even though AMC had not obtained a smash and grab decision in its favour. And that's, I'm going to hand over to Daniel.
Thank you very much, James. I will try my best to leave some time for questions. I've got 3.5 cases sort of to bang through. Now, if you've attended any of the last few updates, you've probably heard me talking at least once about how difficult it is to resist enforcement of an adjudicator's award based on a natural justice challenge. And you probably also heard me being quite dismissive and joking a little bit about the efforts that some parties go to resist enforcement on that basis. But it turns out that natural justice challenges are a bit like London buses. You wait for an age and then two come along at once. Two of the cases I'm going to talk about today are cases where an adjudicator's decision was not enforced, in both cases because the adjudicator had decided the case on a basis that hadn't been argued by the parties or canvassed by them. So the first one, Van Ord. This is a Scots case in the Court of Outer Session concerning whether the adjudicator's award was unenforceable. Now, when we're talking about these principles, it's the concept of an adjudicator going on a frolic of their own, right? Going off and deciding the case, deciding the dispute on a basis which the parties haven't argued before them. I always quite like the imagery of an adjudicator, Matt Malloy or Franco Mastrandrea, having a think about their decision, going for a little wander and a frolic through a meadow and coming up with their reasoning. But anyway, leaving that aside, the principles are quite well known here, and they're cited and analysed in the Van Ord case. If you want a refresher, it's a good place to go. The basic principles are that each party must be given a fair opportunity to put its case. Well, that seems obvious. It does slightly raise the question, what is a fair opportunity? If the adjudicator makes their own inquiries or proposes to use their own expertise, they should let the parties know, give the parties an opportunity to say something. The adjudicator shouldn't really decide a point on a factual or legal basis that hasn't been argued by either party. Although they can do so if the parties are aware of the supporting material and have had an opportunity to address it. But then underlying all of this, and slightly at tension with the other principles, is the idea that an adjudicator should have quite a lot of leeway in how they reach their decision, and in general also with the policy that adjudicators' decisions should be enforced where possible. So what happened in this case? The essential issue in the adjudication was as to causation of delay. And as they are wont to do. The parties' delay experts disagreed about almost everything, including which was the appropriate baseline program to use. They disagreed about almost everything else, including what was the, quote, critical date for a particular delaying event, which was relevant to a notice argument that the responding party was running. They were saying, in effect, you should have told us about this delay notice or delaying event sooner than you did, and your failure to do so means that you've lost your right to claim an EOT. Now, what the adjudicator actually did in their decision was adopt a baseline program that neither party said was the right one, but for whatever reason, the adjudicator thought it was. This had an important implication for that time bar notice argument that I just referred to, because it meant that the adjudicator identified a different critical date to that advanced by either party as well. And what the adjudicator didn't do was go to the parties and say, look, I think both of your experts are wrong. I think it's actually, this is the right baseline program and this is what it means for critical date. He didn't do that, just went straight on, issued the decision on the basis I've set out on that slide. The contractor who was trying to rely on this decision said, well, that's all fine. That doesn't really matter, because all the adjudicator has actually done is pick a midpoint. The one party says this is the right baseline program, one party says this one, he's picked one in the middle. And there is an authority called Miller Construction in which an adjudicator had to consider allocating responsibility for defective work, effectively a sort of standard design workmanship type dispute. And where the adjudicator ended up in that case, I think, reading between the lines, it was a classic splitting the baby type of decision where the adjudicator went, you both seem like you're not entirely blame free in this scenario, so I'm going to allocate liability 50-50. And in that case, the Court of Outer Session again said, that's fine, you can adopt an intermediate position there, and you don't necessarily have to give the parties notice that that's what you're planning to do. In this case, though, the Court of Outer Session said no. They accepted that the line in relation to what counts as going off on a frolic and what does not is not always an easy one to draw. And they said in this case, if all the adjudicator had done was say, I like this baseline program, not that one, not that one, that might be adopting an intermediate position. The problem here, and what made this issue really material and important, was the implications that that decision has for the time bar argument. And because by adopting this intermediate position without telling the parties, the adjudicator had deprived one party of the opportunity to say something about notice and time bar, it was held that this was a material breach of natural justice and therefore the decision could not be enforced. Moving on now to Liverpool City Council and Vital Infrastructure. This is another frolic case. And I think both of these cases illustrate to an extent that although the line is hard to draw, usually if there is a frolic, you know it when you see it. And what happened in this case, there was an issue about the applicable rate for maintenance of temporary fencing. And there was a bill of quantities with 4 rates for maintenance of different types of fencing. 3 were expressed as a rate per metre per day. So if you get 10 metres of maintained fencing and you maintain it for 10 days, you get 100 times that rate. But 1 is expressed as a rate per metre only. Now, in the court's view, it was pretty obvious that a mistake had been made. The court said no one could sensibly believe that's what the bill of quantities meant, because you get the same rate for maintaining a bit of fence for a day as you would for a year. It was perfectly clear that a mistake had been made. The adjudicator also thought it was perfectly clear that a mistake had been made, but he didn't think it was open to him within the terms of his reference as defined by the notice of adjudication to make that finding. Without going into the detail, I assume it was some issue about whether or not he could rectify the contract or take account of this mistake. So what he did was write to the parties and say, look, it seems to me pretty obvious there's a mistake here in relation to this bill of quantities rate. I don't think the notice of adjudication allows me to fix that. So either will you, responding party, agree that there is an obvious mistake and let me make my decision on that basis? Understandably, responding party was not too keen to take up that invitation. Alternatively, referring party, do you want to withdraw your notice, go away, have a think about it, and come back with a fresh one that does give me the power to reach the decision which appears to be the right one? Now, rather unfortunately, for whatever reason, the referring party said, nope, we want to plough on ahead with the notice we have. The adjudicator then did his best and tried to reach the right result anyway, but in a way which, on its face at least, seems a bit unusual. What he decided was that there had been an admission by the responding party that there was an error in the BOQ, and therefore he could decide the case on that basis. The court said, no, that wasn't permissible. There hadn't been any such admission. The fact that the adjudicator knew there hadn't been any such admission was pretty clear from the terms of his email in which he invited the responding party to make an admission. And as a result, he's decided a case effectively on a basis that neither party is contended for, that it's pretty clear is unjustifiable. This is a classic frolic of his own, and therefore decision not enforceable. As I say, two natural justice cases coming along at the same time, although I think it's fair to say that successful natural justice challenges remain rare. The third case I want to talk to you about is Metropolitan Borough Council of Sefton and Allenbuild. Now, if you are a bit of an adjudication nerd like me and you like to use words like juridical and things like that, then this is a really, really interesting case. If you're not, which is entirely sensible, then it's less interesting. But in any event, this is what the case was about. There was an NEC contract which had a fairly standard tiered dispute resolution clause, where first it's adjudication, and then if adjudication doesn't resolve the dispute finally, the unhappy party can stick in a notice of dissatisfaction within a certain period, and then later on they can go off to arbitration and have the dispute finally resolved. That's what happened here, or the first steps happened here. There was an adjudication, one party wasn't happy. And so what they did, when the successful party came along and tried to enforce the decision in the TCC, the unsuccessful party said, aha, but there's an arbitration clause here. And this dispute about whether or not we should pay the adjudicator's decision is fundamentally a breach of contract claim, because the adjudication itself is a creature of the underlying construction contract. The arbitration clause is prima facie broad enough to cover breach of contract claims. In fact, that's pretty central to what it covers. Therefore, this adjudication enforcement action and the dispute as to the enforceability of the award or the adjudicator's decision is within the scope of the arbitration clause. Therefore, we should have a stay pursuant to Section 9 of the Arbitration Act, and all of this should be dealt with by an arbitral tribunal. Now, just pausing there, I think it's worth acknowledging what the practical implications of that argument would be if correct. And we will all have seen lots and lots of contracts, construction contracts, that have the same sort of tiered dispute resolution clause, adjudication followed by arbitration. We will also, I suspect, have all done adjudications and enforcement actions where we have an arbitration clause lurking in the background, but everyone just sort of ignores it or doesn't mention it for the purpose of enforcement proceedings. And it may well be that no one really gives any thought to whether or not that arbitration clause bites on enforcement proceedings, for the very simple reason everyone just assumes what you do in relation to enforcement proceedings is you go off to the TCC. But if that argument is right, how would it work? You win your arbitration, other side says, no, I don't want to pay that. I think that decision is, sorry, you win your adjudication, other side says, I'm not going to pay the sum I've been ordered to pay because I think the decision is unenforceable. So then you have to go off and you have to enjoin an arbitral tribunal to consider those issues. How long might that take? Months at least, I would think. You get then an arbitration award saying, yes, you can enforce your adjudication decision. But of course, an arbitration award is not directly enforceable in the same way as a judgment. So then you have to go off again to court and say, well, now I've got two bits of paper. I've got my decision from my adjudicator and I've got my award from my tribunal saying, yes, the adjudicator's decision is enforceable. Can I now, please, get summary judgment and finally get around to sending the bailiffs in or taking someone's cars or whatever it is you might do in order to try and get your money? Now, with that in mind, with the sort of impractical implications of this, I think it's fair to say that the party running this argument had a bit of an uphill struggle. And the way they argued it was to put lots and lots of emphasis on party autonomy and the principles that we all know well from cases like Fiona Trust, where it is assumed that parties with an arbitration clause intend their disputes to be caught by that arbitration clause, what we sometimes call the one-stop shop idea. If you've got an arbitration clause, generally you are taken to intend that everything comes within that arbitration umbrella. And what the court said is, well, that is absolutely fine, but that rather misses the point, doesn't it? Because the real issue is a question of contractual construction. Is the adjudication enforcement action within the scope of the arbitration clause? There is no problem in principle with parties saying, yes, we want arbitrators to consider questions of enforceability rather than the court. But is that the case with this particular arbitration clause? Now, the court refers in some detail to a really interesting decision of Mr. Justice Dyson, as he then was, in Macob and Morrison, where there was a clause which sort of expressly conferred jurisdiction on an arbitral tribunal in respect of adjudication issues. And what Mr. Justice Dyson said, in a bit of judicial cleverness, was, well, if you've got that sort of clause, you as the party who doesn't want to pay the adjudication decision can make an election. You can either say that this adjudicator's decision is without jurisdiction and therefore a nullity and of no effect. But if you do say that, necessarily you are accepting that the arbitral tribunal doesn't have jurisdiction over it because it's just nothing. Therefore, you have to go to court and argue it out there. But if you decide you do want to arbitrate in respect of the enforceability of the adjudicator's decision, then you have in effect accepted that it is a valid decision within jurisdiction, and therefore whatever arguments you might have in front of that arbitral tribunal, they are not going to be arguments that go to whether or not the adjudicator acted within their jurisdiction. Now, given that virtually every argument about enforceability of an adjudicator's award is an argument about whether or not it is within jurisdiction, this is, as I say, a bit of judicial cleverness, which in effect is just shutting the door to this course of action and saying, look, even if you've got quite a strong clause, the TCC is still going to claim jurisdiction over enforceability of these awards. The court in this case, in Allen Bills, took a slightly different approach, without saying that Dyson had got it wrong, in fact endorsing his approach, but they approached this particular case slightly differently. The court emphasised the content of the rules which governed this adjudication, or which should have governed it, which emphasise that the decision of the adjudicator is binding until the dispute is finally determined by legal proceedings, by arbitration or by agreement. And the court said that what binding here means is that the parties have agreed that the decision is provisionally enforceable until the substantive dispute is finally resolved in litigation or arbitration. And the court emphasised they weren't reaching this decision on the basis of policy grounds. It really was an analysis of the contractual intent. Now, I read this part of the decision a few times because at first glance, this seems to just be kicking the issue down the road. So doesn't it just beg the question, well, is the adjudicator's decision binding or not? And why isn't that, in principle, something that the arbitral tribunal can decide? I think the answer is that there is a distinction between the substantive dispute and the enforceability of a decision about the substantive dispute. So let's imagine, for example, the simplest possible construction dispute. I have built a wall and we are arguing about how much I'm owed to be for building that wall. And I get my adjudication decision, and the adjudicator says it is £100, right? So I've got my adjudicator's decision prima facie binding. Now, the tiered dispute resolution clause provides that that's not the end of the road in respect of the substantive dispute. Either party can go off to arbitration or to court, whichever the clause provides for, and say, actually, no, it's not £100 that I'm owed for doing that wall, it's £200, or if it's the other way around, it's £50, whatever it might be. And so we have effectively a redo of the substantive dispute. Distinguish that from a situation where we have a decision and it's about the enforceability of that. That's not the same thing as taking the substantive dispute up to the next tier in the dispute resolution mechanism. That is a wholly separate dispute. And so for those reasons, I think the court was right to find here, independent of all the policy grounds that you might pray in aid, but the court was right to find here that the arbitration clause did not bite. Very, very quickly, because I can see Stacey is there, I just wanted to mention this case, NJCH and Liberty Homes. This was a case in which the TCC gave a freezing injunction in support of adjudication enforcement proceedings. Have a look at it, perhaps on your own time. Just something to bear in mind if you have got, for example, a naughty subcontractor who you suspect is going to go bust and phoenix themselves while you're trying to enforce your adjudication decision. The TCC will, in appropriate circumstances, probably quite narrow circumstances, use its jurisdiction in respect of freezing orders to help you out, perhaps. I'll stop there, and now I think we've got 3 minutes, sorry everyone, for questions.
No, Dan, Adele, James, thank you very much. We obviously had a lot of ground to cover within the past hour. Everything from insolvency, smash and grab, true value of adjudications, arbitration proceedings, the timing of London buses, and the frolicking of well-known adjudicators who leaves us with that image. But it was fantastic. Thank you for the clear and very concise summaries of those cases. We might squeeze in one question, possibly two. I know if the audience will bear with us, it might be quite nice to just take one or two if we can. Dan, maybe since Allen Build is fresh in our minds, and we know you love the case, how about this one? What if the parties expressly agree to confer jurisdiction on an arbitrator to determine the enforceability of an adjudicator's decision? Would a clause like that have any teeth? I think you might be on mute, or is it my session?
There we go, I've got it, sorry. I mean, I think the lesson from Allen Build is perhaps, but as you can see from that Dyson sleight of hand that we looked at, I think the court will work quite hard not to give effect to a clause like that, if at all possible. If you're completely express about it and you say the arbitrator or an arbitral tribunal have jurisdiction to decide these issues, I think it's difficult to work around it, although I can't think for the life of me why anyone would want to agree to a provision like that, where, as I mentioned, all you're doing is sticking this extra stage in the adjudication enforcement, which is going to cost money and take time.
Thanks, Dan. And Adele, I'm going to come to you quickly about on the insolvency theme. There have been a couple of questions that have come in, but I'm going to pick one. Where does the current case law leave parties in financial difficulties who are insolvent or facing insolvency and who want to adjudicate, given the tricky, as you mentioned, interplay between the adjudication and the insolvency regime?
Yeah, okay. Well, Bresco, I think, leaves us in a position where obviously an insolvent party is still permitted to pursue its adjudication, and the responding party will be permitted to raise its cross-claim as a defence, but not to recover money, even if the cross-claim is bigger than the claim. The court's obviously very clear as well that there's nothing really to alter the common perception that enforcement is unlikely in most cases. Now, the possible exception to this position is that if the insolvent company can offer some sort of ring fencing, but again, that's still quite a high bar to jump over. You know, they literally have to be sort of very clear and unequivocal as to the security that they can provide. So in the great majority of insolvencies, it's difficult to see how ring fencing could be offered. That's not to say that it's not possible. You know, certainly if you do have a third-party funder there that's willing to put the money up. But the current case law probably only really helps well-funded liquidators. I mean, logistically looking at it, the solvent respondent will not be able to stop the adjudication at the outset, even if it has a cross-claim. So the best it can hope for really is a zero award from the adjudicator, which, you know, I understand is pretty disheartening, given that defending an adjudication is often costly and it can use up a lot of time and resources. Though conversely, if it loses, the respondent will probably successfully resist summary enforcement. So obviously it's all still very much a matter for the facts, but the current position as it stands seems to leave parties facing claims from insolvent companies with the choice of either contesting claims on the merits or trying to settle, which is very much a whistle-stop tour, I appreciate, but I know we're stuck for time.
Yeah, thank you, Adele. That's brilliant. I think we're gonna need to end on that, but thank you very much to the audience. And there are a couple of questions we obviously couldn't get to, but please feel free to reach out to any of the speakers, and perhaps they might be able to deal with those by email as well. Thank you again. I'm on the last slide. There we go. Thank you again, Dan, Adele, and James. And so it just leaves me to wrap up the session in our usual way with our marketing of our next webinar, which is now scheduled for the 13th of October, where we have partner Claire King and Senior Associate Mark Pantry, who are going to join us, excuse me, and talk about early contractor involvement, in particular, but not limited to, the NEC option X22, and they'll go through the ins and outs and the opportunities and the challenges. Also, I have put on there, if you're interested in any of our know-how newsletters, the link there how to subscribe, as well as if you're interested in upcoming events, you've got the link there as well. And just a quick reminder that absolutely, for those who missed the beginning, the slides and a recording of this session will be available on demand on our website fairly soon. So thank you again. Thank you to everyone who has joined us here today. We hope you are well, and we very much look forward to seeing you again soon. So hope you are well and stay safe wherever you might be. Thank you. Have a good day.